Okay, welcome everybody to the Saturday night VSOF free online law classes, and tonight's topics will be Class 6, which is Grand Juries, Power and Use in America. And the documents for tonight's class you can find in Class 6 docs and links, and I also linked them into the classroom for tonight. And the first thing that we want to open up and take a look at is going to be the Civil Grand Jury Manual. Now, this is out of California for all of you people out there. Now, this is, of course, the grand jury manual that the state obviously writes up. So they're not going to tell you everything in these manuals about what you can do. However, there is one interesting thing about California that I learned a while back, and that is that there are two grand juries basically running in each county, which is fine. You can do this, but one of them is a civil grand jury, and one of them is a criminal grand jury. Now, I know that sounds rather odd. Roman civil law grand jury. Well, basically what the civil grand jury does is that, and we'll see this in this book, what the civil grand jury does is they pretty much hold the purse strings for the county. So just like Congress holds the purse strings, supposedly, for the aspect of, say, military spending. Okay, well, civil grand juries hold the purse strings for the spending of the county, their expenditures. And that goes everything from the district attorney's salary to how much the sheriff gets. Okay. And funding of jails and everything else. So getting into this fun little book, just in the table of contents, and I'm going to blow this all the rest of the way up for the recording so that everybody can see it. We have table of contents, organization chart, city, county, San Francisco, which is what this one's from. Grand jury instructions by the presiding judge of the Superior Court. Well, guess what? A grand jury can be sworn in by a judge, but once they're sworn in, there really isn't anything, technically, that the judge can tell them to do. So these are all just suggestions. Okay, there's nothing that anybody has to follow in here. But I did find this interesting reading from the standpoint that they have the oath. So when we form our own grand juries, proper 25-member grand juries, then, which by the way, these are not. So these civil grand juries are basically advisory, and nobody technically needs to listen to them. But when you get 25 members of the peerage, then everyone should have somebody administer the oath. And you can have a notary administer oaths. So it doesn't have to be a judge or magistrate. And the reason it doesn't have to be a judge or magistrate is because that we, the people, can form grand juries whenever we want to. And we can even do it in secret, which is clearly laid out in the Magna Carta. And in U.S. versus Williams, it says, the Supreme Court said that, yes, the people can form grand juries whenever they want to, and they can investigate whatever they want to, simply because they want to make sure that there's no corruption or anything going wrong. They don't have to have a reason to investigate. They can just do it because they want to make sure everything's running smoothly. So to continue here with the table of contents, we got oath of jurors, charge of the court, conflict of interest code, which I'm not exactly sure what that is, so that'd be something interesting to look at. Nature and background of the grand jury. So they do give the people a little bit of information. So page 15 to page 21. Well, great. It's a whole 6 pages. Not exactly very much information to go on. But, and I seriously doubt the Magna Carta is brought up, but nevertheless, at least it's better than nothing. Whoops. Suggested procedures for organizing. See, again, suggested procedures for organizing. They can't tell the grand jury what to do. So it's just suggested. You guys can have suggestions. Introduction, procedure, first meeting, session in general, suggested procedure, suggested rules, right? These are all suggestions. They don't, because there's nothing they can tell them to do. Committees, committee procedure, work committee preferences, preliminary titles and areas of work for committees, duties, the four-person pro tempore secretary. You can also have a treasurer too, if you want. Usually there is, and we're going to want to check this for every county and state that each and every one of us are in, but there should be a amount of money set aside in each county for the grand jury, meaning money for postage, money for hiring process servers, money for ink and printers and paper and all of the stuff that you'd want to have available when you're organizing and performing the functions of a grand jury. Now, are all the states like that? I don't know, but I know that California does set aside money for the grand juries, and I did put in the grand juries section from Corpus Juris Secundum, which is volume 38A, and I'm just going to open that just really quick just to make sure that it what I'm looking for is actually in here. Yeah, I'm sure it is. I think I might have even highlighted it. There should be a section in here, and forgive me for jumping around a little bit, but I wanted to make sure and show everybody what the Corpus Juris Secundum said regarding grand juries de jure and grand juries de facto. There's a place in here, Corpus Juris Secundum says 38A, says that grand jury, so under de facto grand jury or juror, which is section 9. So it says de facto grand jury or juror. Authorities differ as to whether there can be a de facto grand jury. Well, guess what? If they're not 25, they're de facto. There is no such thing as a de facto grand jury in a federal court. Well, again, I would argue with that. I'd say, nope, if you don't have 25, it's still a de facto grand jury. But anyway, up here, it says, there cannot be a grand jury de facto when there is a grand jury de jure. And it's got a little number 61. So you come down here to 61, and here's the case. It's an Illinois case. People versus Brautigan, let's say. Brautigan. That's an Illinois case. Can do a little copy and paste onto the classroom real quick. And so the point is that in this, meaning that this is stating straight out that there are de facto grand juries, and that when the de jure grand jury comes into effect based on that case, the de facto has to step out of the way, basically. So if anybody ever questions what we're doing as far as when we create a grand jury, we can just come and show them Corpus Juris Secundum. Be like, hey, I'm sorry, you guys don't have 25 in your grand jury. We are the grand jury de jure, and you're the de facto, so you cannot be in existence. So you've got to step down and stop what you're doing, and give everything to us, basically. So anyway, I just wanted to make that little point before I continued on. And now going back to now I'm going to switch back to the civil grand jury manual. So, okay, so suggestions, all these fun suggestions of what you can do, what you can't do, or what you suggestion to do. Like I said, they can't tell you what you can or can't do. Publicity, which is actually something interesting that you can do. And no, I'm not streaming tonight. Publicity. Okay. After you formed your grand jury, you guys got 25 people that have ready to go. And again, like I said, this is preferable that the 25 have their doc set done, because the doc set will protect you from any of the de facto administration of your estate. And then also the other thing is that if you have all 25 that have done their doc set and you are functioning as a grand jury, you can serve the Secretary of State and the Attorney General and the governor of your state as a grand jury, meaning all 25 of you can serve the state, your doc set, as a functioning grand jury and say, look, we're a grand jury, we've done all this, we've claimed our estates, we're out. If you guys cross us in any way, shape, or form, or attempt to administer anything regarding this grand jury, which is also an aspect and right of part of your estate to convene, then they would be not only would it be grand jury tampering, which you could then instantaneously indict them for anyway, but you could do all kinds of interesting, wonderful things. Like you could put them all through binding arbitration, and then, as far as I'm concerned, considering a grand jury can do damn near anything it wants to, and I'm going to look this up, but I'm just putting it out as a preliminary thought bubble, if you will, that once the binding arbitration comes back, I don't see there being any reason whatsoever why a 25-member grand jury can't confirm the arbitration award on their own volition. There should be absolutely no reason why they can't do that. Now, granted, the particular estate and people who have gotten the binding arbitration award probably should not be sitting on the grand jury for the vote. That would be a conflict of interest, but there's nothing saying that you get one more, and then fine, and you can confirm it yourself through grand jury, and there wouldn't really be anything that any judge could say either. You could actually a grand jury could force a judge to sign off on it, basically. So, you want to talk about absolute power? Well, there you go. So now, of course, he'd be signing things to bankrupt probably some of his idiot attorney friends, but who cares? That's not my problem. If they didn't want to be bankrupted, then they should stop administering our estates as if we were dead and had not yet come of full age, and so on and so forth. So back to publicity. Sorry, I skipped over that. So back to publicity. The aspect of doing a press release. You get your 25 together, and like I said, if all 25 get your docs done, you can serve the state, the governor, the attorney general, secretary of state, and I'd probably serve the treasurer too, but serve all four of them. And so they're gonna get a banker's box full of stuff. And then once you do that, the publicity aspect of it is that you can put an ad in the whatever is the state newspaper. There's at least one state newspaper, and this goes to statute. It's in every statute that when you place an ad or a notice, I should say, in a particular newspaper, and like I said, this is done by statute in every state. Every state has one. It usually should be the state journal or something to that extent. And if you publish it for 3 consecutive weekends or 3 consecutive weeks, which is basically just the Sunday printing for either 3 or 4 weeks, and it depends on statute, whatever. And you can follow it. It's just good to follow it, just because then it's you're following both common law and civil law. Not that you have to follow civil law, but it causes a lot less waves if you do it so. And you publish it for 4 weeks saying, hey, we're a grand jury. We're meeting in such and such county. Got any problems? Bring them to us. And you might be surprised what you get. You might actually get sheriff's deputies coming and bringing you stuff. You might get county board members. You might get, who knows who coming to you, right? To help fix, solve, investigate, and indict, the issues of the county. So it's a good thing to do that. And it's also a good thing that when the grand jury decides something, when they investigate and put together a true bill and put it forth, that they also, again, publish it and say, yes, we the grand jury have formed a true bill and bring indictment against so-and-so for doing such and such, and we have passed the true bill on to the district attorney whose name is such and such, and demand that within 30 days he act upon the indictment. And failure, and say something like failure to do so will will then place Mr. So-and-so district attorney under investigation and indictment of the grand jury. Well, you wouldn't want to say indictment because that would be threatening, but you get the point. Use the newspapers. Use them. They're public notice, and they're statutory public notice. So once you get it going and set it up like that, then that would be what you'd want to do to then control your county and your state, and let the whole rest of the state know at the same time that, hey, you guys can do this too. And like I said, you might be surprised who contacts you. you'll want some sort of mailing address. You could probably set up a P.O. box if you wanted to. There's a possibility that there already is a P.O. box set up for the grand jury of your county. I would just look into it. If not, set up your own. Doesn't matter. And make sure that somebody checks it every day, so to see what's in there. And so that's your preliminary organization. And I know this is a civil grand jury, but there's a lot of information here. It's 186 pages, so there's a lot of information here that can be drawn out from to be used in criminal grand juries as well. So let me just move on here. And I'll cover a few more things. So powers and duties, governmental affairs. This gives you an idea of some of the things you can do, even though that's probably limited. But we'll check it out, because I do intend to go through pretty much this whole entire manual, because again, it's civil, and again, it's from the de facto, but it's good to just look over something like this and go back and forth between what would be de jure and what, other things that you can do. And I could probably put notes in here as we go along. So limitations on investigatory power, the grand jury, and the city attorney. So there is no limitation on the investigatory power. You can subpoena whoever the hell you want to. They don't show up, hold them in contempt of the grand jury, throw them in jail. They don't give you a document, throw them in jail. Period. It's what they did in Hale versus Hinkle, and I don't see any reason why that should not still be used as a weapon for disobedience. These people are servants. Every single corporation is a chartered entity. It exists because we allow it to exist. Every single record that they have is ours. Period. If they're causing harm, even more so, investigate all of it, then pull their charter. Anyway, to continue, elected officials, other city and county officers, grand jury reports. The reports are interesting. Now, a grand jury report is something that you put together on not only each indictment and true bill that you create, but the grand jury can also create reports of everything that it investigated during a quarter. And you usually want to do them by quarters. You wouldn't want to go past a quarter. So you want to have a grand jury report each quarter as to what you did and didn't do. And then if you have another 25 that come in afterwards, because people don't want to do this forever, obviously. That would be overly burdensome to anyone. So you do want to have rotations. Personally, there's probably should be pretty much a fresh 25. Maybe a couple people can stay over if they want to, or if people are retired and this is what they enjoy doing. No problem. But, I would try and shoot for 100, basically 100 in each county. So you've got 25 that you can rotate, each quarter. So people can do it for 3 months and then, have the rest of the time off until it comes back to their time again. So those are the reports. We'll get into that. Civil liability of grand juror, suggested outline of report. That just gives you an idea about how to make the reports. So, this is an interesting little thing to read. Advice and assistance, correspondence, grand jury files, and library. So, yes, you should keep a grand jury file and you should keep a library. You should also find out if there is already one in existence in your county. Clearly, California has them already. But check your state. And then when you do find and check your state, please, everybody, do everybody else a favor. In the VSOF server, go down to under reference, go down under state law and case law, click on it. Every single state is in there. Find your state and then post all the information that you find about a grand jury for your state. I mean, that's why I set up the states, so that we can start collecting the information that we need to, and that everybody only has to find it once and then post it, and then we're good to go. And we can keep the information also, the organizers for each state, and that can be, basically whoever just takes the reins, will be able to have another repository. I highly suggest that every state and every county set up a free Mega Dropbox account, the same way that I share documents with everybody on the server. Set up a free Mega account because it's encrypted and the U.S. government can never mess with it, because Congress tried to take out Mega a while back. And the owner basically said, I, I don't have any of the encryption keys. They're all on the user side. So if you want something from the user, you're going to have to subpoena every single user for every single folder that you want, because I don't have them. So that pretty much, that was the end of that in Congress, because they weren't going to go through all that shit. So that's why I use Mega, because it's easy. And Mega's actually, if you want to just get the upgrade for 400 gigs. But 400 gigs is pretty good. It's a pretty nice little side thing that you can be able to share. That's how I share everything with everybody on the server. And I would highly suggest that everybody that starts a grand jury, and even that just starts to get your state organized. I mean, you have to organize your states before you just start running off and making grand juries. There are some people out there right now that I'm actually in correspondence with that, and some other people agree with me, that they've kind of jumped the boat a little bit and gotten ahead of themselves. And I understand that people are frustrated, and understand that they want things to happen quickly. And I also understand, and I'll probably get there someday too, hopefully, that when people get older, they have more sense of an emergency and immediacy to their actions, because they want to see it within their lifetime. I completely understand that. And like I said, I'll probably get there myself rather quickly, but I'm always a stickler for making sure that you do things right. If you do not do things correct, don't do them at all. Let somebody else take care of it, or ask somebody else that knows more about the subject than you do to help instruct you how to do something correctly. Do not just wing it. That's the last thing you want to do, because if you have a bunch of idiot infants out there that are just winging all this various different stuff, like I could name people, but I won't. What it's going to look like in the totality of the cause, it's going to make everybody look like, oh, look, they're all just a bunch of infants. They all need administration. You see how stupid they are? They all need administration. That's the last thing you want to end up doing. It only hurts the scenario, because honestly, this is the last thing. Everything that I'm teaching through the vocational science of freedom, this is the last thing we have before absolute total war. And if you don't understand that, you haven't done enough of your homework yet. You haven't read things like Quiet Weapons for Silent Wars. You haven't read the report from Iron Mountain. You haven't read and gone through and understand the occult side of all of this to, like the extent to say like Bill Cooper did. Or you're already in a war. They want you dead. I don't think there's any question about that anymore regarding, the COVID garbage and the forced vaccinations and, well, forced whatever. Again, I go back to what Michael Badnarik said. You bring your needle, I'll bring my 45, and we'll see which one makes a bigger hole. Well, that's a libertarian presidential candidate for you. So that's where I've always been at. And because I realized after I fully understood that, one, all of the states are conquered territories after the Civil War, the Reconstruction Acts are still in full force and effect, and that, the United States government is a corporation that was established in 1871, I believe. Correct me on that if I misquoted there. And with the Washington, D.C., or District of Columbia Act, sorry. And knowing all that, I'm fully aware of what the situation is, and I'm fully aware of where we're at here. Are we behind the 8 ball? Yeah, of course. But at the same time, we have all the power. So don't get worried about it. Don't get upset about it. It's just power we haven't been wielding for a while. It's no big deal. We can pick it up and wield it again whenever we want to. We just dropped the scepter about 100 years ago, and no one has bothered to pick it back up. So, and there's a lot of work to be done after we do pick it back up, no doubt there. But again, just do not do something half-ass. Understand what you're doing. Make sure that you have all the literature. I've provided all the books you guys will ever need. I found everything over 25 years. It's all in the folders. I give it to everybody for free. And if you want more information, I do have it. Then, if you want to organize an entire county and have absolutely everything that I've ever collected, which would be probably more than necessary, but anyway, if you want it all, my hard drive is for sale. So that would be, and you then organize everything out of that, because this is just one of many, 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 many things on grand juries, including my grand jury manual, which I have written a grand jury manual, and it's about 350 pages. It's not completely done yet. I still need I need an editor, because actually Michael Badnarik was doing some of the editing a while back. And so I need another editor and to finish it out. And when that gets done, then I will put that up probably as an ebook, just so I can make some compensation off of it. Because it took me 6 months to write it. I didn't do anything basically for 6 months, and sat in a friend's basement and basically did nothing but write that grand jury manual. So there's a lot of information in there, which Michael told me I tend to try to make people drink from a fire hose, which I thought was an interesting way of putting it. But at the same time, I'm not trying to sugarcoat this for anybody. You either learn the information and do it right, or don't do it. You can learn it. It didn't take me that long to learn it. Take a month to learn it. If you're going to complain about taking a month out of your life to secure your sovereignty, your freedom, the protection of your children and your grandchildren, what the fuck are you doing here? Go someplace else. Go live in a communist country where daddy will take care of you, and you can wear your gold chains and be happy the rest of your life. Not my problem. My situation, my problem is to fix what's here and to do it correctly, and so that hopefully when we're done, never have to do it again, which is the point. So I'm going to skip forward. This is an interesting little thing. This is a San Francisco city and county government overview of how it's organized, right? A good thing to have. And if you don't have one of these, figure it out. Figure it out for your county. Make one. Make one so that your grand jury has a chart like this. So it's very easy to follow, so you know who's above who, where, what, all of it, right? So grand jury instructions by the presiding judge of the Superior Court. Again, Superior Court, that means court of record. To the grand jury of the city and county of San Francisco, ladies and gentlemen, it is my duty under the law to give you some instructions concerning your function as a civil grand jury, and also concerning certain rules of law that apply to your work. On the outset, I think you should bear in mind that the institution of the grand jury is one of very ancient origin. Yes, it predates the Magna Carta, because technically the Court of 100 was the Celts and Druids, Saxon people. It was their grand jury. It was the way that they functioned, their grand jury, even though they didn't call it that. It wasn't called that until 1215, until Magna Carta. So its use as an instrument of government antecedes the introduction into our county during colonial times. Yes, as I just mentioned. It has been continued and used throughout the whole of American history. Also true. It is not, however, my purpose today to go into historical development of the grand jury. Well, obviously, but everyone should know what it is anyway. It is sufficient to point out to you that it is an institution of great importance, great power, and therefore great responsibility. Yeah, great power is right, because there's nothing above it. You are all familiar with trial juries to which litigants in certain civil cases and defendants in all criminal cases are entitled under the provisions of the Constitution. I should say Constitution for the United States of America, but whatever. And of the state of California. Those juries must, of course, be distinguished from the body known as the grand jury. Correct. The grand jury is one of the few instrumentalities of government wherein the proceedings are allowed by law and required by law to be secret. Notice that he underlined that. Now, they can be. They are not required by law to be secret, so that judge is actually incorrect. That's just that they can be secret. Now, the reason that they want to keep all of the things in the grand jury secret under the civil grand jury, these de facto grand juries, is because they don't want anybody educated into what your power actually is or what is going on. Now, I can understand, of course, the aspect of secrecy. I'm not saying to publish every bloody thing and to tell everybody what you're doing. Certain things should remain secret. It's great. Fine. No problem with that. But is it required by law to be secret? No, it is not. You can publish things however you bloody well want to. and there's nothing he or any other judge can say about it. The reasons for this secrecy are good, and they are important. The grand jury is designed not only to investigate matters that would otherwise not be acted upon because of the unwillingness or the inability of individuals to bring the complaint, but also to protect persons from the publicity that otherwise would be involved should complaints eventually prove to be unfounded. Well, that's all well and good. However, if they're public servants, the publicity should be out in the open because they're public servants, right? They're trustees. So, therefore, every member of the grand jury shall keep secret whatever he or she and any other grand juror has said, or in what manner he or she or any other grand juror has voted on a matter before them. That's good to keep the voting, secret. You don't need to go off and say, I voted for so and so, I voted for that, whatever. So that's fine. All that stuff's secret. And just like a regular teacher would be. The law further provides that every grand juror who, except when required by a court, willfully discloses any evidence adduced before the grand jury or anything which he or she or any other member of the grand jury has said, or in what manner he or she or any other grand juror has voted on a matter before them, is guilty of a misdemeanor. Well, great. Under what? Roman civil law bullshit. Doesn't apply in a common law grand jury. Doesn't apply in the least bit. But you see how they try to scare the infants, right? That little paragraph, that little sentence right there is just trying to scare the infants into saying, oh, if you don't do what we say, you're kind of guilty of a misdemeanor. No. Try that, we'll indict you for treason. Just turn around and throw the hammer, on top of their head. The law also provides that a grand juror cannot be questioned for anything he or she may or say, or any vote he or she may give in the grand jury relative to a matter legally pending before the jury, except for a perjury of which he or she may have been guilty in making an accusation or giving testimony to his or her fellow jurors. And yeah, that's true. They can't be questioned about anything they're up to. So you say you're forming a grand jury, you start an investigation. The district attorney says, what are you doing? You say, none of your business. Right? So the civil grand jury may at all times ask the advice of the court or the presiding judge thereof, or of the city attorney in civil matters, or district attorney in criminal matters. But unless such advice is asked, the judge of the court, city attorney, and the district attorney of the county may appear before the grand jury for the purpose of giving information or advice relative to any matter cognizable by them when so requested by the civil grand jury. So yes, anytime that you want to question any of these people, just tell them, send them a nice letter first and say, hey, we'd like to talk to you on such and such day. Could you please show up? If they send you a letter back saying, go screw yourself, then you can send them a subpoena and say, no, now you will show up, or we'll hold you in contempt. So you can play that as strong or as light as you want to. As members of the civil grand jury, your jurisdiction is limited to the examination of the conduct of your city and county governments. That is true. A grand jury should not cross county lines dealing with other counties' business. Okay? You can deal with the entire state matters if you wish, if that's what you're doing, meaning a state grand jury, that's fine. But when it deals with county matters, deal with the matters in the county. Do not be crossing county lines, because then technically you are, in a way, trespassing upon the jurisdiction of your fellow people in your next county over. And that's not what you want to be doing. So it's boards, commissions, departments, and bureaus, and into the conduct of any elected official. Let's think about that for a moment. Any elected official. How about an electoral judge? How about all of the people that had anything to do with counting votes in this last election? Right? Some of those people are going to be elected officials. Yeah. So, in order to assure yourselves and through yourselves, the public, concerning the stewardship of the representatives of the public in our city and county, the grand jury normally conducts its investigation in secret sessions. But there is a special provision that they may hold open sessions when directed to do so by an order of the Superior Court, finding that the subject matter of investigation is one affecting the general public welfare, respecting matters involving the alleged corruption or misfeasance or malfeasance in office. See right there. Okay, so they actually say it, what I just previously said. They're telling you. Yeah, when it deals with public welfare and it deals with anything malfeasance, corruption, any of that, you can totally open the whole entire thing up to the whole entire public. Tell everybody to show up and bring every single piece of evidence that they've got against whoever. You can clear a county and a city out faster than anything doing that, because you'll have people coming out of the woodwork saying, "No, I've got this, I've got that, I know this, I know that." Okay, great. Yeah, bring it. You probably rack up more. You'll rack up so many indictments. Some of these people would sit their whole life in jail. In fact, the vast majority of some of these crimes being aspects of common law theft. Just start building gallows. So anyway, so of public officials, public employees, or of any person allegedly acting in conjunction or conspiracy with such public officials or employees in such alleged acts. So, like I said, go crazy. It is also the duty of the civil grand jury to investigate and report on the needs of all county officers in the county, including the abolition or creation of offices and equipment. Therefore, right, purse strings again, or the method or system of performing the duties of the several offices, and it shall cause a copy of such report to be delivered to each member of the Board of Supervisors of the county. So, yeah, so when you get the reports done, you should give them to your county board members or Board of Supervisors, whatever you got running, however your county structure is set up, and say, yeah, you guys that are running the county, this is our report of what we found. And, you know, thank you for cooperating. And the next grand jury will continue on the report and continue where we left off. And, you know, we'll give you another report in another quarter. You know, thanks for your service, and we'll see you in a little while. Got any problems? Come to us, right? Because we're the power here, not you guys. So, the civil grand jury, according to a special provision, may inquire into the case of every person imprisoned in jail of a county on a criminal charge and not indicted. Interesting. And shall inquire into the condition and management of the public prisons within the county. Also, again, interesting. You want to stop every single corrupt corporate charge that's all these commercial charges. Put your grand jury together, go to your jail, subpoena the entire jail record, meaning everybody that's in there, and then everybody that's sitting in that jail that does not have an actual indictment from the 25-member, meaning from you guys, okay, and that they're in there on some commercial crime, the grand jury themselves can inquire on habeas corpus to the sheriff and say, why are all these people sitting in jail? None of them are indicted. None of them were, you know, caused damage, harm, loss, or injury. Now, make sure that they didn't. I mean, if somebody did, okay, fine, leave them in there. But again, then instantaneously do a true bill and no bill on each of them, right? Throw everybody else out. All of you get out of here. You have no business being in jail. A grand jury can do that, clearly. But I would do it by common law, proper common law habeas corpus, which is where you sue out the habeas and say to the sheriff, you demand that the sheriff produce the damaged party. And the other thing that you always want to make sure that the sheriff produces is that you demand that the sheriff produce a valid warrant of commitment, which they never do. They never create these anymore. The filthy Roman civil law system just doesn't do it because it's just paperwork, and besides, it's something you would have to do at law anyway, so they're not following law. A valid warrant of commitment has to be signed off by a magistrate who had 2 or more witnesses give testimony at a proper evidentiary hearing. It's called a show cause hearing. Sometimes called a show cause, sometimes called preliminary. It has different names in different states because, well, the statutes did whatever. Attorneys call things different things. But basically what it is it's a hearing that has to happen the second that someone gets arrested. They have to be taken directly before the nearest and most accessible magistrate. Now, here's the thing. Every single man or woman that's sitting in that jail that did not have a preliminary hearing and was not taken directly before the most before the nearest and most accessible magistrate from the very point, the exact longitude and latitude of where they were arrested, and they were taken directly to the jail, you can instantaneously throw all those people out of jail and be like, nope, you're not holding any of these people lawfully. They're all free to go. And there wouldn't be a damn thing that the sheriff or the district attorney or any judge could do about it. Nothing. Because if they tried to do something, you could indict them. Be like, oh, you're tampering with the grand jury, are you? You want to be held in contempt of the grand jury? Then get out of our way, right? So these are these very basic due process lessons that once you understand are unlawful, then all you have to do is just correct them. And I can show you guys all the places where it is, as far as and I have in the past, as far as case law is concerned regarding that particular issue, which would be Heath Boyd out of Texas is a good one, and then Gerstein versus Pugh, which is a Florida case, another good one. There's multiple other ones, and every single, as far as I know, I've never found a state that doesn't say this. Every single state in their criminal procedure will say that exactly what I just said, that they have to take the person who's been arrested directly before the nearest and most accessible magistrate for a proper evidentiary hearing, with or without warrant. Even if they're arrested on warrant, they still have to do it and say, yep, we got him. Or, yeah, there was a warrant, matches his description or her description. We brought him before you, as it says. Then and only then does the magistrate have the actual capacity and ability to write out the warrant of commitment, which is the warrant of commitment and the arrest warrant are two different things. Okay. The arrest warrant allows them to go out and arrest somebody because they've done damage, harm, loss, or injury, under the common law. Okay, fine. But again, that has to also be done and created by a proper evidentiary hearing. If a judge just can't create an arrest warrant just because he feels like it. Can't happen. Or if he does, he can be held in contempt of the grand jury and he can be indicted for everything from criminal malfeasance in office to violation of due process to, well, it'd be a lot of things. But anyway, the warrant of commitment is different than the arrest warrant. The warrant of commitment is the thing that gets created when there's enough evidence to say, yes, this person needs to be in jail and there needs to be a trial had on his behalf. Now, yes, of course, he can bond out or bail out, which then the bond hearing is held after the warrant of commitment is created. But here's the point. You go to any jail. If these people do not have the warrants of commitment, meaning the sheriffs do not have the warrants of commitment for each and every man and woman that's in their jail, they are 100% commercially liable for unlawfully holding those people. And technically, every one of those people could turn around and sue the sheriff. And you could very quickly end up bankrupting probably an entire county in lawsuits on simply that one thing alone. Now, I wouldn't specifically go about telling everybody that was sitting in jail that they could do that, because we have to fix this in a way where we're not just completely destroying the infrastructure without putting up a new one. Again, that's the last thing you want to do. What you want to do is you want to have a transition. So, yeah, could they sue technically? Yeah. But unless they listen to this show, probably not going to. But the grand jury can still get them all out. Okay. So anyway, so that's that as far as criminal procedure, due process, grand jury power, what you could do with habeas corpus, all based on a one sentence out of this grand jury manual. Okay. So to continue, in connection with this investigatory phase of your work, I wish you to point out to you that the civil grand jury is not intended to be and should not be made a super government for this city and county, period. What he's saying is, well, you guys have all this power, but please don't use it, or else, you could tip the whole thing. You could tip the whole apple cart over. Well, again, as I said, be diligent with your power, but do not wreck things simply for the sake of wrecking them. Make sure that there are contingencies in place that will be up and running before you go and do something like that. Because the last thing you want is a situation where, say, you've bankrupted a whole county or a whole sheriff's department, and it gets out, the information gets out, obviously, that there's no sheriff's department, or there's hardly any deputies, or whatever, or nobody's manning the jail, meaning like you can't go to jail in this county. You know what's going to happen, and I can guarantee you that will happen. And you already know where my mind's going. So you'd have to have a full, you'd have to have a full militia going. You'd almost have to have probably like a suggested ordinance from the grand jury themselves. Well, not that a grand jury can create an ordinance, but basically saying a county-wide, putting up like, say, a county-wide mandate that everybody has to be armed at all times, something like that. And there have been counties that have done that in the South. And surprisingly, they have some of the lowest crime rates in the entire, all of America. So just a lesson as far as statistics is concerned regarding that little issue. But again, so that's what I'm talking about. You have to prepare your fertile ground before you start planting the seeds. The ground must be ready for seeds. You can't go throwing seeds out on, a bunch of rock. All of them are just going to fly away in the wind until they do find some fertile ground. So you have to make the ground fertile. And the analogy I'm making here are the minds of the people of the county. Let them understand what's going on. Educate them, meaning create documents or just tell them to come listen to these classes. Either way, it's fine. But put information together that is clear, concise, and if you need to, just use the treatises that I provide for you. They're just as good today as they were when they were written in, late 1800s or whatever, regarding common law and grand jury power, including, for an example, this going over this little de facto civil grand jury manual. You wouldn't want to just necessarily give this to somebody, but say, here, go use this, without them going through and listening to this class, because I'm going to go through a vast majority of this thing. This might take all of the next 5 weeks, maybe, because I'm going to be very, very thorough, because I want to be very specific with people about what is and what is not possible. And reading this will show you where the de facto is trying to restrict your power and trying to guide people onto a path that they shouldn't be on, and that there is a clear path that you should be following, and it's in the rest of the documentation which I provided for the class. So, which we'll get into, which we will eventually get into. I'll make sure that everything gets covered. Again, we're going to be covering all of the non-numbered ones. So I stopped at 10. So wherever I stopped at 10 last time, these were all things that we'd already gone over. 1 through 10 is things that we'd gone over in previous grand jury classes. So everything below that. So the Civil Grand Jury Manual, which is this we're going over. Ron Paul organization put together a great little document on grand jury power. We'll go over that eventually. Corpus Juris Secundum I just brought up, so you guys can look at that at your leisure. But it was just that one part of it that I wanted to make sure of. Grand jury, George Edwards. This is a whole book on grand juries. 1906. So again, the time is good. Just before they really started screwing everything up after 1933. And I know I'm bouncing around here, but I just want to show you guys what it was. So the grand jury, an essay, and 1906, and it's 300 pages, right? So it's probably, I don't know what exactly all the totality of it covers. I did look at the table of contents, and I was impressed. So this is one of these things that you can just have and take the time to read when you get ready to start putting your grand juries together, right? So anyway, back to the Civil Grand Jury Manual. Okay, so we got down here. Okay, only when public officials violate applicable criminal or procedural laws, or so abuse their discretion as to violate the spirit and intent of those laws. Now, here's the thing. So abuse their discretion. What are chancellors? Chancellors are just people up there holding the conscience of a king that doesn't exist anymore. Okay. You think they might be abusing their discretion a little bit. Say, as in stealing houses for the Khazarian mob through a completely fraudulent mortgage and foreclosure system. You think that might be abuse of discretion? Just a little bit? Yeah, I would say so. Okay. Do they become proper subjects for comment or action by a grand jury? Granted. Fine. But at the same time, remember what it says. You can investigate even to just make sure that they're not violating. You don't have to be violating anything. So again, this is kind of them trying to steer the sheep away from what their actual power is. You don't want to be wielding too much power here, guys. We want to control you, but they can't say that they control you, which is why everything is a suggestion. But they put language like this in there to try to control them anyway. So examination for certain prior purposes, make your inquiry as though it may be necessary to achieve the purpose of the statute. Again, you don't have to follow statutes because you're having a common law grand jury. These guys are following the inferior. Well, sorry, I shouldn't say inferior. The de facto grand jury, civil grand juries run these things by statute. In a common law grand jury, you're not using statutes. In fact, never use a statute. As far as like quoting it and saying, we're doing this on the statute. Never, ever, ever do that. You could take, if you like what the statute says, you could take the verbiage straight out of it and say, this is what we're doing. But don't ever say that we're doing it based on the statute, okay? Never. Or you'll put a monkey wrench in the whole thing and you'll basically become de facto, even if you had 25. So never use that, because the statutes are Roman civil law. It's their side of their commercial system. We're not indicting people for commercial crimes under the filthy law merchant, okay? We're only doing true bills and indictments against men and women who have caused damage, harm, loss, or injury to someone else, another people, or their property, okay? That's it. Stick with that, you'll be good. That's really pretty much the basis of what you should base any investigation on. So, to continue, at the present time, there is in existence a second grand jury, which is called the indictment grand jury. So like I was saying, in California, you guys have two of these. Now, pretty much from what I've come to conclusion by reading, and I've read most of this document already, and is that what they're calling the indictment grand jury is basically what would be the common law grand jury on the criminal side if it had 25. But they don't. So again, there's just basically two de factos in California. But the indictment one is the one you would do for criminal matters, right? So the indictment grand jury hears evidence in felony cases presented to it by the district attorney. The second grand jury has sole and exclusive jurisdiction to return indictments. If during the course of your investigation you should receive information concerning criminal matters, it is you. What should be? It is your. I should say your. Oh well, typo. It is your duty to report these matters to the district attorney. If appropriate, looks like another typo, to the indictment grand jury. It should just say if, and it should say and if appropriate to the indictment grand jury. Well, here's the thing: the district attorney doesn't have any power to yay or nay anything, nothing. What you do with an indictment is give it to them and say, here, indict, right? Go get them. And if they don't, well, there's been plenty of times in history, American history, where the foreman himself or herself, whatever the case may have been, they turn around and they turn around and prosecute the true bill of indictment in a court of record. I recall that there was and if anybody wants to go searching for this, we should find this and actually put it up for information for everybody else, because it was such an amazing story. From my recollection, and I don't have the paperwork on it anymore. I had it at one time, but that was like 2 computers ago. And there was a grand jury that was formed in Minneapolis, St. Paul. And this was shortly after World War II, I believe. There was a lot of shenanigans happening on local governments being corrupt right after World War II, because basically all the good men went to go fight, and you were left with a bunch of scumbags here that corrupted everything, which is, of course, also where you get the siege of Athens as well, with the voter fraud back then, and them. Well, I don't want to get into that. But point is that this was a deal with the mayor and the police chief both being corrupt in Minneapolis, St. Paul. And the grand jury investigated, found evidence, returned a true bill of indictment. District attorney said, I'm not prosecuting. Foreman said, yes, you are. He said, no, I'm not. He said, fine, we'll prosecute you too. And brought a true bill of indictment against the district attorney. And then the foreman prosecuted the case against all of them. And every one of them went to jail from what I remember. And so I think maybe the mayor resigned preliminarily or something like that. And that was like copped a deal or something. But all of them got removed from office. And I'm pretty sure that the other two went to jail. And so what you're looking for when you look for information about the power of grand juries and what they can do in this instance is look for the term runaway grand jury and search for newspapers. If you can find a newspaper that has all of their archives now digitally and they've got a really good database, search every single newspaper you find in every major city from 1900 to, well, go from 1900 to 1933. If you want to go a little bit farther past that to get after the Second World War stuff, then go to 1950. Search from 1900 to 1950 and search for one term, runaway grand jury. And you'll probably find, well, if we make a database of this, we will have the largest I can guarantee you, we'll have the largest database of true grand jury history that anyone's ever put together. And that is that would be extremely important for everyone else to follow, because we wouldn't have to prove anything. We would just say, here, go look in our database. This is your power. We're not making this up. It's all in history. Go look it up, right? But having story after story after story after story like that would shatter the thick skull of any sheep that comes along and says, you can't do that. Well, yes, we can. And yes, it's been done before. And guess what? We're doing it now. So with that, I think I'll put a bubble note in here. Or actually, no, I can't because it's locked. Wait, hold on. Oh, can I enable editing? Oh, yeah, I can. Okay. I'll put a bubble note in here where we left off. And I will come back to this next Saturday. This exact same thing. You guys are welcome to read it, and you're also welcome to download everything else that I put into the folder tonight. But we'll come back to this exact place, and I'll save it. And this will be the one that gets saved on the server because I believe I pulled it directly up on the server. So it'll get saved in there. And then we'll come back. So does anybody have any questions for tonight as far as grand juries are concerned? Or any other questions for that matter? If not, you guys can always ask me questions in the server. And again, for anybody that may be watching, if you'd like to join the Vocational Science of Freedom Gilded server, the URL is simply, let me scroll down and show it to you guys, is gilded.gg/VSOF. So that's all you have to put in, and it'll bring up on a web browser. And then what you want to do is download the application and install the application, and then put in this into find servers. Sorry, so it'll be over here. So you click on this little create group or join group. So you hit this little button right here, and then you put that in, and then you'll come into the server, and then up here at the top it'll say follow or apply. Make sure that you hit apply up here, and then answer the questions, and then that'll get you into the server so you can interact with us. If you just hit follow, you won't be able to interact. So that's it for tonight, and I thank you all for coming, and we will continue this next Saturday right where we left off with grand juries. And I'll turn off the recording now, and we can talk amongst ourselves.